Can everyone hear me this morning?
I can hear you.
Okay, cool. So again, today's webinar is being recorded and will be available on youtube.com/Chicago BACP. All BACP webinars are a part of the BACP Entrepreneur Certificate Program, which is a free program for anyone interested in starting or growing a business here in Chicago. And getting your certificate is as easy as 1, 2, 3. Register for the program, attend 6 webinars within 6 months, and graduate. Once you graduate, you now become eligible for a loan with our partners at CIBC Bank. For full program details, please visit chicago.gov/BACP certificate. And at this time, I will now turn this webinar over to Adam for us to begin.
Thank you. And hello, everybody. My name is Adam Weller, and I'm the Assistant Commissioner with the City of Chicago's Office of Labor Standards. Also joining us is Richard Ruff, who is a Supervisor of Investigations, who will be assisting with any questions that may come in through the chat or Q&A box. So today, our topic is updates to the FAQ documents and a new interactive webpage. So we will review the more significant changes to the FAQ documents that we have on our webpage, and we'll introduce our new interactive webpage, which is designed to enhance public transparency around complaints and investigation outcomes. So we made updates to our FAQ documents for the following Chicago labor laws: Fair Work Week, minimum wage, and paid leave and paid sick leave. We incorporated questions that we received by email, telephone, in person, and from webinars. I want to remind everybody that the FAQs do not represent legal advice, and that employers should consult their own legal counsel to determine any actions that they should or should not take to comply with labor laws. So let's review how to access the FAQ documents. If you visit the OLS website, which is at chicago.gov/labor standards, you scroll down to the Chicago Labor Laws ribbon and select the appropriate labor law that you want to access. From that new page, you scroll down to the resources section and find the frequently asked questions hyperlink, which is identified in a red rectangle. So we'll begin with the Fair Workweek ordinance. This had the most significant changes to the FAQ document, so let's lead off with that. So added questions to the document include, does the Chicago Fair Workweek ordinance apply to independent contractors? And that answer is no. The ordinance only applies to employees as determined pursuant to IRS guidelines. How does the Office of Labor Standards count employees to determine employer size? And since Fair Workweek protections are dependent on employer size, we often receive this question from employers that are on the cusp of the employee count. So to answer that question, we calculate an employer's size by averaging the number of all employees, and that includes full-time, part-time, seasonal, temporary, and interns, who worked for compensation during the previous 12 months for all weeks in which at least one covered employee worked. To calculate a new employer size that hasn't been around for that same time period, we'll count the average number of all employees who worked for compensation during the previous 90 days. When does a temporary worker, so a worker that works for a day and temporary labor service agency as an example, or a staffing agency, become a covered employee? A temporary worker becomes a covered employee once they work 420 hours for an employer within an 18-month period. If the temporary worker becomes a covered employee, their employer, often a staffing agency or similar, must meet the criteria for an employer in order to receive Fair Workweek protections. So what that means is that if a temporary worker meets that threshold, that their employer also must be primarily engaged in a covered industry. So if they staff individuals at an array of types of businesses, and those are not primarily a Fair Workweek covered industry, then they would not be primarily engaged in that industry to qualify as an employer. So there are multiple levels to that. Can an employee request changes to their work schedule? Yes. A covered employee has the right to request a modified work schedule, including but not limited to additional shifts or hours, changes in days of work, changes in shift start and end times, permission to exchange shifts with other employees, limitations on availability, part-time employment, job sharing arrangements, reduction or change in work duties, or part-year employment. However, the employer has discretion as to whether to grant schedule request changes. It is best practice to have employer policies in writing and ensure that the policies do not discriminate on the basis of race, color, creed, religion, ancestry, national origin, sex, sexual orientation, gender identity or expression, disability age, or marital or familial status. We also added an entire new section focusing on advance notice of work schedule. So for this example, our question states, when do employers need to provide employees with a work schedule? Employers must provide employees with a work schedule at least 14 days in advance of the first workday on the work schedule. So this example that we provided is if an employer posts a schedule on Monday, July 7th, 2025, the first workday on the schedule should be no earlier than Monday, July 21st, 2025. That is 14 days before the beginning of that work schedule. What information must the work schedule include? The work schedule must include the hours, days, and times for all regular and on-call shifts for the work period. The schedule must include the specific start and end time for each shift. Is that 14-day advance notice based on business days or calendar days? It's calendar days. How long of a period should the work schedule cover? So the Fair Workweek ordinance does not regulate the length of the work schedule. It could be a week-long schedule, a month-long schedule. That's up to the employer to decide. But whatever the duration of the work schedule, the employees must receive 14 days advance notice of that work schedule. If an employer makes multiple changes to a single shift, could the covered employee be owed more than 1 hour of predictability pay? Yes, so each schedule change should result in predictability pay. And we provided a couple of examples for this. In example 1, the covered employee was scheduled to work from 10 a.m. to 5 p.m. on April 10th. The employer changed the covered employee's shift with 7 days notice, so within the 14-day period, and changed it from 12 p.m. to 7 p.m. That's a single schedule change. Then, 3 days before the shift, the employer again changes the hours to 2 p.m. to 9 p.m. In that instance, 2 hours of predictability pay would be due. In our second example, the covered employee was scheduled to work 9 a.m. to 5 p.m. on November 28th. At 12 p.m. the day before, less than 24 hours before the shift, the employer changed the shift to 8 a.m. to 1 p.m. This is a schedule change and a reduction in hours, which means that 1 hour of predictability pay would be owed for the change, and 1.5 hours would be owed for subtracting hours less than 24 hours before the shift. That 1.5 hours is 50% of the 3 hours that were cut. So in total, in that instance, the covered employee should receive 2.5 hours of pay for those changes. Is there a grace period for time worked before or after a shift when predictability pay is not owed? So OLS allows for a 15-minute grace period on a single end of a scheduled shift before requiring predictability pay. An example of this is if an employer asks a covered employee to stay up to 15 minutes past their shift to complete a task, then no predictability pay would be owed. If an employer asks a covered employee to arrive 15 minutes before their shift and stay 15 minutes after, then that would exceed the single 15-minute grace period and predictability pay could be owed. Under the exceptions category of our FAQ, we have the following questions. Does the acts of nature exception include a rainstorm which forces an outdoor patio to close? Our answer to that is no. The examples provided in the ordinance include flood, earthquake, tornado, or blizzard. And those are major disastrous weather events, which may force a business to close entirely due to safety reasons. If a business is unable to reopen due to damage caused by one of the aforementioned acts of nature, then that exception would still apply. Do planned protests qualify as civil unrest or threats to public safety under the Fair Workweek exception? Generally, no. Unless public safety officials order or recommend business closures, or there is an imminent threat of property damage, then planned protests would not qualify as exceptions. Do all shifts separated by less than 10-hour rest periods qualify for right to rest protections? No. The second shift must occur either less than 10 hours after the end of the previous day's shift, or the shift started the previous day and continued into the next. So there's 3 examples for this as to when it would apply and when it may not. So in first example, employee A works a shift ending at 9 p.m. and is scheduled to work a shift beginning at 5 a.m. the next day. This employee is entitled to right to rest protections. It's within 10 hours of the shift that started the previous day. Example 2, employee B works a shift starting Monday at 11 p.m. and ending on Tuesday at 3 a.m. Then they start their next shift that same Tuesday at 9 a.m. This employee is entitled to right to rest protections. That shift started the previous day. In our third example, this employee begins a shift at 1 a.m. and ends the shift at 9 a.m. The employee then works again at 3 p.m. That employee is not entitled to right to rest protections because both shifts occurred within a single day. We also added an illustrative example regarding publicly available shifts. So in an example where an employer posts extra available shifts publicly, either physically or electronically, for employees to request extra shifts, that would not result in predictability pay since the employer is merely making it known that there are opportunities to pick up shifts, at which time the employee initiates the change to their schedule by then requesting the additional hours to the employer. So for minimum wage, the content in our FAQs primarily remained the same. We just added a single question and then of course updated the minimum wage table to reflect the new rates. You see the updated table there with the minimum wage rates for different types of workers. And the added question is, I have fewer than 4 employees. Which minimum wage must I follow? City of Chicago, State of Illinois, or the federal minimum wage? So employers with fewer than 4 employees must follow the federal minimum wage requirements. City of Chicago and State of Illinois both require, both have a minimum of 4 employees to qualify for the minimum wage law. Now we'll focus on updates to the paid leave and paid sick leave FAQs. So does the Chicago paid leave and paid sick and safe leave ordinance apply to independent contractors? Generally, no. The ordinance only applies to employees as determined pursuant to IRS guidelines. Whether an individual is truly an independent contractor is determined by the economic realities test that is used by the Fair Labor Standards Act. This note below reminds you that the ordinance does apply to all domestic workers, and that is regardless of their status as an employee or independent contractor. In order to qualify, they must still meet the 80 hours worked within 120 days threshold to become a covered employee for that ordinance. Does the ordinance apply to employees covered by collective bargaining agreements? Employees covered by a CBA that was in force on July 1st, 2024 are not subject to the provisions of the ordinance. However, once the CBA expires, a union and employer can negotiate over the terms of paid leave and paid sick and safe leave, including whether to waive the requirements of the Chicago paid leave and paid sick and safe leave ordinance. If they do so, a waiver should be set forth explicitly in such agreement in clear and unambiguous terms. There are different ways to accomplish an effective waiver in a CBA. One example that OLS recognizes for the purposes of enforcement is as follows. A waiver of Chicago paid leave and paid sick and safe leave ordinance. To the fullest extent permitted, this agreement shall operate to waive any provisions of the Chicago Paid Leave and Paid Sick and Safe Leave Ordinance, MCC 6-130, and shall supersede and be considered to have fulfilled all requirements of said ordinance as presently written and/or amended during the life of this agreement. That text does not have to be verbatim in a CBA. However, that is a waiver that our office would recognize as being clear and unambiguous. This question was important to add because we do receive a number of complaints and questions from individuals covered by a CBA that was in effect prior to the ordinance taking place, so we wanted to clarify this. If a covered employee works outside Chicago, can that covered employee still accrue paid leave and paid sick leave? Hours worked outside Chicago do not count towards the accrual of paid leave or paid sick leave for the City of Chicago's ordinance. But note that hours worked outside Chicago may be subject to the Illinois Paid Leave for All Workers Act, also known as PLAWA, or the Cook County Paid Leave Ordinance. If you work in Cook County, but not in Chicago, you should direct your questions to Cook County Commission on Human Rights. If you work in Illinois, but not in Cook County or Chicago, those questions regarding PLAWA should go to the Illinois Department of Labor. Also, for any questions you may have regarding jurisdiction on the different types of paid leave or paid sick leave, we have a jurisdictional comparison chart on our website as well. Our overtime hours for non-exempt employees worked by an employee counted for accrual purposes under the ordinance. Yes, employees eligible for overtime under the Fair Labor Standards Act should have their hours counted for accrual purposes under the city's 1 hour accrued for every 35 hours worked metric. For exempt employees, do those overtime hours count? No. For employees who are exempt from the overtime provisions of the FLSA, paid leave and paid sick leave accrue based on a 40-hour work week, unless the exempt employee's regular work week is less than 40 hours. In instances where there is evidence that the exempt employee's regular work week is less than 40 hours, then paid leave and paid sick leave accrues based on that regular work week. Can a covered employee use paid sick leave to care for adult children? Yes. The ordinance allows covered employees to use paid sick leave for the care of a child, regardless of age. Does a dentist or eye doctor appointment count as acceptable use of paid sick leave? Yes, it does. Just like a medical appointment with a doctor, dentist and eye doctor appointments qualify as receiving professional care, including preventive care, diagnosis, or treatment of a medical issue. And so that concludes the updates to our FAQ documents. And at this point, I would like to introduce you to our new interactive webpage. In order to access the new webpage, you can use the direct link as shown below, which also appears in a Google search for OLS reports and investigations, or from our main OLS homepage, which is chicago.gov/labor standards. You can scroll down to the reports and investigations ribbon and click on the blue hyperlink below, which states reports and investigations webpage. So I'm going to take you to our webpage now, if you'll bear with me. Okay, so at this point, you should be able to see our new reports and investigations webpage. So when you land here, you'll see an explanation that the following dashboards will allow you to search complaints that are submitted to our office, along with resolved investigation outcomes. So we have two different interactive dashboards. The first one is an investigations dashboard, and I will expand this into full screen so it's easier for everyone to see. So with our investigations, you have an option of choosing information on settlement agreements, mediations, or citations in these tabs above. You can also filter by specific years. Right now we have selected all, so you can see our total number of settlements since 21, 22, 23, 24, and 2025. Number of impacted employees, fines paid specific to settlement agreements, and total financial recoupment to workers. We also have remedies by employer legal name. There are 3 different options to see what those remedies were. There's fines paid, which are going to be financial fines to the city. We also have paid leave hours. So those are hours of paid leave or paid sick leave that were ordered to be provided back to employees. And also financial recoupment that went directly into the pockets of Chicago workers. Now, if you're only wanting to focus on a single year, let's say we just want 2024, you can select by the year itself, and all of the data on the top ribbon changes. There's also different types of graphs or charts with additional information. But this information tells you in 2024, we reached 34 settlements, $137,000 in fines paid, and over $670,000 in recoupment. If you're interested in mediations, which are just going to be informal mediations between OLS and the employee and the employer, you can be specific with mediations. Same thing, you can choose the year that you would like to select. If you hover over to the different charts, additional information will appear. And there's also information on citations that we have written regarding labor laws, along with a map of locations of where those businesses were. You could hover over and it'll give you business information. It'll give you the number of citations over time, the different types of municipal code violations, what those municipal codes were, and citations by business. So an interactive tool to be more transparent about the labor laws investigations that we've conducted and their outcomes. We also have a dashboard for complaints. Which I will expand. So we have a map that you can select your specific area. So right now we are in community area, or you could select by ward within the map. You can use the map functionality to select the area that you are inquiring about. And this will be for the entire date range up at the top. So whichever time period you're seeking, that's the information that you're going to get. Right now, we have from the launch of our office at the beginning of 2020 until October 4th, and we have received 3,410 complaints during that period. If you want to adjust a date specifically, you can type it into the date range, and I went 1 year ahead, and you can see that the number of complaints has changed. We have our complaint status, ones that are in progress, ones that are closed, complaint type information, and then a bar graph here showing the ordinance type and their status. If you don't want to type this in, you can also use the slider tool, and it will provide you information based on that date range. If you're curious about your specific ward, you can select the drop down instead of using the map functionality. So let's just say that we're going to pick the 4th ward right here. The information that it then provides you is specific to that ward only for the date range that you have selected. If you want to work in community area, select the community area button, and you can either drop down and select from the dropdown, let me get out of the fourth ward. I will select all. Or there is functionality to search for your neighborhood. So if I want to choose Brighton Park, I can use the search functionality and it will pop up. So there's a lot of interactive tools within the dashboards, but if you want a full explanation as far as how to operate the dashboards, we also provided Power BI instructions for the dashboards, a little manual. So the manual here will give you an entire guide as far as different interactions, such as hovering, map navigations, and functionality of the entire dashboard. So you're not on your own just going to the website and trying to figure out how to work a Power BI dashboard if you are unfamiliar with this technology. So we provided a user manual to help assist you through this process. And that will conclude the information that I plan to share for the FAQs and the dashboard manual. If anybody has any questions, those can be provided, or you can reach out to our office. I will provide the contact information for us.
All right, Adam, looks like you've done. Did you want to wait a couple more minutes in case they got more questions?
Yeah, we can wait a few more minutes in case.
The question was popped up.
Sure. Okay, we do have a question. Let me read that. So the question that came in is, do employees need to say they're using a paid sick day or paid leave day, and how much notice do they need to give? So if an employer has a differentiation between paid leave and paid sick leave, the employee should state what type of use that they are using. If the employer requires that in their policy, an employer can provide notice for paid leave not to exceed 7 days. So if they're using paid leave, you can require that an employee provide up to 7 days, but you can't require that they provide more than 7 days for the use of paid leave. There is no such requirement for paid sick leave because illnesses are unpredictable. However, if it is reasonably foreseeable, they should provide as much notice as possible. And what we mean by that is, let's say you have a medical appointment 5 days from now, you scheduled it, you're aware of it, you should give as much notice as is reasonably foreseen for that employer.
Remember, today's webinar is recorded and will be available on our YouTube channel at youtube.com/Chicago BACP. If you are a part of the BACP Entrepreneur Certificate Program, you will receive credit for today's attendance within the next 24 hours. It looks like they are good. Any final words, Adam? No?